уважаемые участники.
Distinguished participants of this roundtable discussion, dear guests, this roundtable discussion is dedicated to interaction of national courts, interaction between national courts in the framework of competition of jurisdictions. How courts should respond to decisions made by courts in other countries, while national courts would consider that to be under their own jurisdiction instead. How you should address somebody else's cases, where those are involved in the orbit of this or that national jurisdiction, while courts may think that involvement is artificial. This is an important issue for virtually all countries. Much will depend there on the policy as pursued by the judiciary, especially Supreme Courts. It could be a position of reasonable restriction or moderation, or a position of expansion beyond one's own national borders. Whatever the case, each version of relationship will have its strengths and weaknesses. The problem is which prevails, strength or weakness. The Russian legal system has been traditionally following the principle of a reasonable reserve. When considering cases falling under the jurisdiction of other nations, our procedural legislation in some cases does allow us to accept cases with participation, with involvement of foreign companies. Still, it is quite often that our position would be this Russian court would be an inconvenient venue for considering such cases. One of the recent cases happened a year ago. That was about a Latvian bank and its depositor, Russian citizen, but residing in Latvia. And we considered then that that case was inconvenient for consideration within the Russian jurisdiction. Although, if, for instance, that bank would have attracted deposits from Russian citizens, possibly the award would have been different in that case. So really much will depend on specific circumstances, and we would like to discuss these with our colleagues now. Let me give the floor, first of all, to the chairman of the Supreme Court of Germany, Mr. Klaus Tolksdorf. You have the floor, please.
Dear President Ivanov, ladies and gentlemen, let me first of all express my sincere thanks for the invitation to St. Petersburg, this beautiful city full of history and full of culture. It is my great honor and also my special pleasure to have the opportunity of participating in the third International Legal Forum and presenting some thoughts on the subject of interaction between national courts in the framework of competition and of jurisdictions to such a select audience. In doing so, I ask for your understanding that I will restrict myself to the German point of view and, being a judge, to the point of view of judges. I would have liked to refer to the specific concern which this topic constitutes to our host country, Russia. But unfortunately, I simply do not know in detail what issues are currently most topical here in Russia. Ladies and gentlemen, how can a competition of legal systems and jurisdictions arise? How are legal proceedings kept away from national state courts and instead brought before foreign state courts or arbitration courts? Well, maybe a distinction should be made between two constellations, also with regard to the assessment of the phenomenon, which I'll talk later on about. On the one hand, the choice of a specific legal order and a specific jurisdiction may be subject to an agreement that has been autonomously negotiated by the parties concerned. On the other hand, the law of different individual states may offer a choice for the individual litigants. Let me illustrate the first constellation, the choice of law and jurisdiction by virtue of an autonomous private agreement, with a concrete example. If two companies of different nationality enter into a purchase contracted concerning a larger volume, they will not only reach an agreement about the primary obligations, object of purchase and purchase price, but also on various other terms and conditions. This will include an agreement as to which substantive law should apply for the contract and which court or jurisdiction should be competent to decide possible disputes. They will select the place of jurisdiction mainly on the basis of which courts appear to them to be the most suitable for settling and deciding possible disputes. Those of the seller's home country or those of the buyer's home country. Criteria for their choice may be the quality of jurisdiction, also measured by the predictability of decisions, the duration of proceedings, and of course, the cost of litigation. The example shows that the choice of law and jurisdiction is part of the market economy process in cross-border legal and economic transactions. In their negotiations and contracts, the players take account of the advantages and disadvantages of different national legal systems and different jurisdictions based on a cost-benefit assessment and make them subject to an autonomous private agreement. Which substantive law shall apply and which court shall have jurisdiction depends on the interests of the parties. And if the parties, as is usual, have different interests, if both sides have greater confidence in their own home jurisdiction, then it is simply a matter of who can prevail. In other words, the market power decides. To some extent, the national legal systems and jurisdictions themselves appear as market participants in this context, since they offer to the globally operating parties as their service certain substantive rules on the one hand, and decisions on legal disputes by courts that are qualified in a certain way and act according to certain procedural rules on the other hand. Thus, they themselves compete with each other to some extent. In Germany, therefore, some politicians, and especially internationally operating law firms, call for promotion of the national jurisdiction, for example, by means of specialized court divisions for international trade disputes, approval of internationally accepted private codifications, unidroit, admitting the choice of functional jurisdiction under exclusion of the successive stages of appeal, and even approval of English as the language of the proceedings. However, I personally am rather skeptical about the last issue, for there is no doubt that the quality of jurisdiction largely depends on the mastery of the language used, and especially of the legal terminology. And I have to admit that British and US judges just master the English language better than German judges do. Ladies and gentlemen, I will now move on to the aforementioned second point, the choice of law and jurisdiction according to a heteronomously given freedom of choice. A competition between legal systems and jurisdictions can also arise if the national legal systems offer the choice for the litigant to pursue his rights based on the same facts in different states. In this case, the plaintiff can establish the relevant law and the jurisdiction by unilateral decision. And this means he has the possibility of the so-called forum shopping. This refers to the practice adopted by some litigants to have their legal case heard in the court thought most likely to provide a favorable judgment. This practice is especially applied in actions for damages. A common example from a German point of view are class actions brought before American civil courts by German plaintiffs pursuing damage claims for antitrust violations, trademark infringements, or product liability. Two things are especially favorable for the plaintiffs. Firstly, the possibility to claim punitive damages, which normally does not exist in the German law system. And secondly, joint and several liability, whereby a plaintiff may recover all the damages from any of the defendants, regardless of their individual share of the liability. Another advantage for the plaintiff can be the pre-trial phase of discovery, in which each party can obtain evidence from the opposing party, and in certain circumstances also from non-parties. This pre-trial discovery can be very expensive for the defendant company. The plaintiff may also benefit from the general rule that extrajudicial costs are not reimbursed. These are very tempting advantages which make it highly attractive for litigants to bring a civil action before an American court instead of a German court. And this is, as far as I am informed from the legal literature in Germany, quite simple. For there is no need of a connection between the legal issues and the jurisdiction in which they are to be litigated. Any business activity of the defendant company in the United States can establish the jurisdiction of the American civil courts. There is another form of the shift of litigations to the most favorable legal system and jurisdiction, which in Germany is discussed under the heading of forum shopping. It takes place in the area of corporate law and is done by choosing the legal form of company. The background is that the European Court of Justice permits the creation of a company in one member state for business activities in another member state. A company which has acquired legal capacity according to the legal system of one member state must be acknowledged by the other member states. Accordingly, national courts must apply the foreign corporate law to the company. As a consequence of this decision, the British private company Limited by Shares, in Germany just called Limited, became very popular in Germany because it requires no minimum capital, unlike the German limited liability company, the so-called GmbH. Another consequence was a substantial competence between the European legislators to create the most attractive corporate law for enterprises. Ladies and gentlemen, what do we, the representatives of the national courts, think about the outlined developments? From my German point of view and from my point of view as a judge, I would say first, as far as the choice of a legal system and or a specific jurisdiction is the result of an agreement that has been freely negotiated by the parties concerned, the state cannot and should not intervene in a regulatory manner. Here we can confidently rely on the free play of market forces and the experience that the better law system as the better product will prevail. In this context, the principle of private autonomy, which has grown over the centuries and which forms the basis of our market economy system, plays an important role. It means giving great freedom to the parties concerning also to the choice of the legal system and the jurisdictions. This is true at least as long as the state fulfills its constitutional obligation to guarantee a consistent and reliable application of the law to its addressees. I have the impression that the competition between different jurisdictions has no negative impact on the German. As far as the competition between public and private courts is concerned, my esteemed colleague, Mr. Vice President of the German Federal Court of Justice, Wolfgang Schlick, will talk to you about the arbitral jurisdiction. Second, I'm a little more skeptical about the competition of jurisdictions and legal systems in the case where the litigant can make a unilateral choice, forum shopping. This is especially true if it leads to unmanageable risks, liability risks for the defendant. It must be determined from case to case to what extent state regulations is needed in this area, for examples concerning the recognition and enforcement of foreign judgments. One thing seems clear to me. It can only take place in the form of international agreements. Finally, also insofar, I believe in the healing power of market forces. Companies feeling that the risk of being sued before a foreign court is too high will withdraw from this foreign market. And if more companies do so, national economic interests will lead the government to accept appropriate international agreements. Thank you for your attention.
Thank you very much, Mr. Chair. I absolutely agree that the autonomy of the litigants concerning the choice of the jurisdiction of the court, if both parties agree to that, must not be put into question. And when difficulties arise, it's usually in different situations. It's usually in other situations when the parties did not express their wills concerning the applicable law and court. And it is then that the problems arise when one could procrastinate certain decisions in a certain jurisdiction or pull a party into another jurisdiction. I would remind you of a case, famous case between the late Mr. Berezovsky and Mr. Abramovich's companies. The case was considered in the UK because one of the parties lived in the UK and the other had all the assets concentrated in the UK companies. That is, he had a lot of assets in the UK. And I'm asking myself a question. What about if a Russian citizen bought an apartment abroad, like many people do? Will that be enough to say that any litigation concerning this person must only take place in a country where that apartment is? I wouldn't say that our courts would take such cases, but I would like to hear about the position of Germany on this issue. Suppose a person bought a flat, an apartment in Berlin, and he's got into a car crash and he is to pay the damages. Is a flat in Berlin enough for the case to be heard in a Berlin court?
Der Streit geht also nicht um die Wohnung. So verstehe ich Ihren Fall.
If I understood you right. If you are talking about an apartment or real estate, it's the German cases that will take the case. If it's paying the damages after a car crash, it's a different matter. Where did the car crash take place? Whether it is in Moscow or in Berlin? Well, I got the answer. Well, it's most important where the car crash is. In Berlin or in Moscow? Yes, I got the answer. Thank you. Thank you. I would like to pass the floor after a request to Mr. Wolfgang Schlipp, because those two presentations are really follow one another and are in the development of one another. On my behalf, I also would express my heartiest gratitude for an invitation to be here. It's very pleasant for me to talk in such a competent audience on the relationship between private arbitration courts and public arbitration courts, and I would present a German view. A few comments. If a decision is made in Germany and the winning party will have a you need a decision by the national German court, the state court can only cancel those arbitration rulings or judgments that are taken by the national court. In principle, we do deal with arbitration courts in other jurisdictions. If the parties are unhappy with the judgment, you can appeal to the Superior Court. The Senate on Civil Issues does that, and I'm the chairman there. The Supreme Federal Judge gets about 10 to 15 appeals a year. 50% is about the judgments by our courts, 50% about the foreign courts. It seems to be a small number of cases to come to the Supreme Court if you imagine the great number of materials related to international trade and so on. And certainly it means that special senates in the land take very high quality decisions, and it also means that the judgments by these courts are accepted, and there is no need for pressure from the part of the state courts in order to carry out those judgments. As for the arbitration court judgments, it's a situation of peaceful coexistence in Germany. The right to appeal to a court is a constitutional right for private autonomy, and the decisions by the parties of what to do in a case of judgment, whether they would use the state arbitration court or whether they would use the private arbitration court. The arbitration procedures provide certain benefits for the parties involved, because the judges must comply with the materials. Those may be experts in different areas, not only lawyers who can be involved in arbitration. The proceedings themselves, the procedure itself is more flexible maybe than the state procedures, and the decisions and the judgments by the arbitration court presuppose performance of the judgments by foreign arbitration courts too, and that is the rule since 1980s, and the parties in that process, unlike the state procedures, they more trust experts' opinions more. But if we're talking about state procedures, the procedural issues are better controlled. Finding evidence is made in a more regular manner, and apart from that, there is another circumstance: the costs of the proceedings is a very important argument for the party that is, so to say, less financially better off. Well, worse off financially. And it's quite obvious that if we're talking about the general agreements or consumer agreements, arbitration courts are not the best tool. If major companies strike international agreements, using the arbitration court provides a lot of advantages, and it's sometimes much better than using the state court procedures. And this is the outlook of a German legislator on that issue. In 1997, arbitration procedures got renovated, and I'm talking about a model law that was taken as a model for German legislation. And the legislators hoped that the international arbitration procedures will be more often used to consider German cases. And so state arbitration courts will be relieved of the burden of those cases. The recognition of arbitration as an alternative to normal state procedures will be recognized in Germany, especially in international conflicts. Arbitration is always an alternative to state courts. An alternative in the sense that the access to state courts is a special procedure, and the right of choice belongs to the parties. In any case, in Germany, there are certain concerns about that. There are concerns that the national continental system versus the Anglo-Saxon system will lose points. And in that sense, there is a desire to bolster up national arbitration in order to counteract this tendency. If you look at the German arbitration and at foreign arbitration, it is better to make a choice and to see in which case arbitration is better than the state court. Thank you.
Содержательное выступление.
Thank you very much for a glorious presentation, and traditionally I would like to ask also one question to the speaker. What do you think signing an agreement about mutual recognition of court judgments between countries, how will that affect the international commercial arbitration? If there is a wide enough, a broad enough agreement between countries, I think the advantage of arbitration will be reduced or disappear or not, or whether those are phenomena that lie in different planes, and such an agreement between countries will not affect international arbitration. What I said is that the purpose of this UN agreement is to bring everything to international standards, and the following result is achieved thereby. The performance of the enforcement of the court decision is made easier abroad, and so the decision by the arbitration court reaches its result. If you apply to a state court, that is a long way, and you should understand that this UN agreement has absolutely different purposes. It is intended for improving the arbitration on an international scale, and it does not reduce the position of the national arbitration courts, and that is positive for the market players. Like I said, in Germany there is no doubt in that sense. We are looking with great enthusiasm at that. The only doubt is that whether it will be affecting commercial agreements, and that is a slightly different topic. All the cases that come to the Supreme Federal Court of Germany in that sense deal with our national companies and enterprises if they are unhappy with the court judgment. Therefore, I would ask in such a manner to that question. This agreement will certainly impair the position of national courts, but you shouldn't be too sorry for that. Thank you very much. I like the answer very much, and I think it touched upon another aspect of that we've so far completely missed in the Russian Federation. I mean the conflicts of a consumer nature. According to the law on the protection of consumers, we are trying to send those cases to arbitration courts, and that's a very important issue. It's very important that in Germany it's being widely discussed. I think we need to think about that further. And now I would like to pass the floor to Madam Zhao Inze, Court of the People's Supreme Court of the People's Republic of China.
Good afternoon, everyone. Yeah, it's okay. Okay, thank you. First, I would like to take this opportunity to express my grateful feelings to the Supreme Commercial Court of Russia and our President. And this is my great pleasure to be invited to this forum. And maybe I can say I'm among the youngest among the speaker, but also among the entire house. So I'm quite flattered of this opportunity to give you a little speech about the Chinese mechanism in coordinating jurisdiction conflicts in international civil proceedings. And as you may know that China's legal system has only been founded for several decades, and it's still young, like me. And it's still in the process of learning and formatting our own unique legal system. And today I would like to introduce some of our existing regulations and practice concerning the jurisdiction conflicts in international civil lawsuits. In my opinion, that jurisdiction conflicts arise in cases when two or more courts from different countries or districts claim or decline jurisdiction over one international civil case at the same time. And I think there are two types of jurisdiction conflicts over international civil proceedings. One is the passive conflicts, which means any court of different countries or districts refuse jurisdiction over one case. And another kind is active conflicts. On the contrary, it means courts from different countries or districts claim jurisdiction over one particular case. And next, I would like to move on to introduce China's existing legislations in coordinating jurisdiction conflicts over international civil proceedings. First, would like to introduce the existing legal system. The Chinese legislation on jurisdiction over international civil cases mainly falls into two parts. The first one is the international treaties concluded or acceded to by China. And the other part is our internal legislation and judicial interpretation made by the Supreme People's Court of China, my court. The first part, the international treaties, mainly including, for example, the Agreement on International Railroad through Transport of Goods, and International Convention on Certain Rules Concerning Civil Jurisdiction in Matters of Collision, and Convention for the Unification of Certain Rules for International Carriers by Air, and United Nations Convention on Contracts for the International Sales of Goods, and other bilateral treaties and agreements. And the second part is our internal legislation and judicial interpretation mainly include our civil procedure law of the People's Republic of China and some judicial interpretation issued by the Supreme People's Court. And then I would move to the main part of my little speech, which is the specific legislation about coordinating jurisdiction conflicts. It's mainly about our nation's some principles that we will apply in dealing with the international civil cases concerning the jurisdiction of international civil cases. The first principle is the territorial jurisdiction. China's territorial jurisdiction mainly based on two factors. The first factor is the defendant's domicile or habitual residence jurisdiction. According to the regulations in our country, that a civil lawsuit brought against a citizen shall be under the jurisdiction of the court of the place where the defendant has his domicile. If the place of the defendant's domicile is different from that of his habitual residence, then the lawsuit shall be under the jurisdiction of the court of the place of his habitual residence. And a lawsuit that brought against a legal person or any other organizations shall be under the jurisdiction of the court of the place where the defendant has his domicile. And it's worth noting that in certain occasions, the plaintiff's domicile or habitual residence may also be considered as the jurisdiction basis. Those occasions including those concerning personal status brought against persons who is not residing within the territory of China, and those concerning the personal status of persons whose whereabouts are maybe unknown or who have been declared as missing. And there are also those brought against persons who are undergoing rehabilitation through labor, which is I think is a unique system in China, and those brought against persons who are in imprisonment. So in a word, when the defendants is maybe impossible to locate, or he's declared as missing, or his freedom is in restraint, so the plaintiff's domicile or his habitual residence will be a basis for the jurisdiction. And here is I just introduced the first factors within the territorial jurisdiction of China. And the second factor is the most related principle. According to the Chinese civil procedures law of China, that in the case of an action concerning a contract dispute or other disputes over property rights and interest brought against a defendant who has no domicile within the territory of China, and if the contract is signed or performed within China, or if the object of the action is located within China, or if the defendant has distrainable property within the territory of China, or if the defendant has its representative office within the territory of China. And our court, where those places that I just mentioned may have the jurisdiction over these cases. And this provision reflects that when a lawsuit bears certain connection with the court, it would create a junction of jurisdiction that which may entitle our court to take this law case under the jurisdiction of Chinese court. And this is the first principle I like to share with you. And the second one is the agreement jurisdiction. In the case of an action concerning a contract dispute or other disputes over property rights and interests, parties may agree to choose in their written contract the courts of place where maybe the defendant has his domicile, where the contract is performed, where the contract is signed, where the plaintiff has his domicile, or where the object of the action is located to exercise jurisdiction of the case. And these provisions must be exercised under the condition that the forum level and exclusive jurisdiction are not violated. So as you can see that in light of the above mentioned provision that agreement jurisdiction in China shall meet with certain requirements, such as it's only applied to cases concerning a contract dispute or other disputes over property rights and interest, and not applicable for cases concerning personal status. And the third principle in our country is the so-called litigation jurisdiction. It's when occasions when parties in international civil proceedings haven't signed any written agreement concerning jurisdiction, nor have they reached any oral agreement. When one party brings a lawsuit in one court, the counterparty appears in court and makes substantial arguments or makes counterclaim. The court may assume that the defendant has subject himself under the jurisdiction of this particular court. The litigation jurisdiction, in essence, I think, is a public power rather than the party's private right. Its ultimate goal is to maintain the legal lawsuit order and interest in the country of the court, and to fully implement the civil procedure law in the court of that country. And the next principle is the exclusive jurisdiction. The exclusive jurisdiction based on one's country's national interest. Some international civil disputes may concern major political interest of one country, interest or national organs or the national public policy. And if the jurisdiction over these lawsuits were not exclusive, one country may lose the capacity to protect relevant interest. And therefore, many countries have integrated exclusive jurisdictions in their civil procedural law. And as for China, there are many cases shall be under the exclusive jurisdiction of the People's Court here as specified. The first is a lawsuit brought on a dispute over real estate shall be under the jurisdiction of the People's Court of the place where the real estate is located. And secondly, a lawsuit brought on a dispute over harbor operations shall be under the jurisdiction of the court of the place where the harbor is located. And the third, the lawsuit brought on a dispute over succession shall be under the jurisdiction of the court of the place where the descendant had his domicile upon his death, or where the principal part of his assets is located. And the above mentioned are several principles that our Chinese courts may apply in our international lawsuits, international civil lawsuits. So in conclusion, that jurisdiction over international civil proceedings in China shall be determined by the following order. The first one is exclusive jurisdiction, and the secondly, agreement jurisdiction, and the third, the defendant's domicile or habitual residence jurisdiction, and the fourth is the most related principle, and the last one would be the litigation jurisdiction. And what I just introduced is some regulations and rules and practices that we adopt today in Chinese court concerning that international civil proceedings. And at last, I would again thank you for our president and our dear colleagues, and thank you for all the guests for your time to listen to a young, new assigned judge to introduce their regulations and legal systems about her own country. Thank you. Thank you very much.
Огромное спасибо. Я тоже не...
Thanks a lot. I will not derive myself of pleasure of asking just one question. Have you heard of any cases where Chinese courts would fail to recognize their own jurisdiction over whatever dispute there may be, saying that the forum was not convenient? Do you know of any such cases in your practice? Thank you.
Thank you for your question. If I understand it correctly, do you mean the inconvenient court principle, right?
That's right.
So the inconvenient court principle, to be honest, there are no existing legislations in China concerning this principle. But as far as I know, there are cases in China that have already adapted this principle to deny our own jurisdiction over particular cases. And since there are no existing legislations, so they are just some when we apply this principle, that in my personal point of view, that China still has a way to go in applying this principle, and this principle must be applied under one particular condition, that is the denial of the jurisdiction over particular cases shall not jeopardize the interest of our nation, our society, and our national citizens or legal persons that concerning in these particular cases. Thank you.
Спасибо огромное. Спасибо.
Thanks a lot. Thank you so much. Now let me give the floor to Mr. Clifford Wallace, Chief Judge, Court of Appeal, Circuit 9, United States. You have the floor, please.
Thank you very much, Mr. Chief Justice, and thank the organizers for inviting me to come for the first time to this beautiful city. It was refreshing as I came in from the airport to find no debris on the street and no ugly signs on the buildings. I know that in Singapore they use caning to accomplish that. I don't think you do here, but I would certainly like to know how you keep the city so clean. It's something I could take back to the United States. As indicated, I am on the United States Court of Appeals. It's the court just below the Supreme Court. Our Supreme Court is very small. There's only 9 justices, and our system is broken into various circuits. I'm in the 9th Circuit, which is the largest circuit in the United States, the largest appellate court in our history. The Supreme Court doesn't take many of our cases, less than 1%. So the great majority of final opinions comes out of the Court of Appeals. That's traditionally the way it's happened, and there is no effort to have every case go to the Supreme Court. I can speak on behalf of my circuit. I can advise you what's going on with the Supreme Court, but I think perhaps I'd better be as broad as I can under the circumstances. What I'd like to do, because of this very intriguing topic of jurisdiction, where conceivably it could be in one of 2 countries, or maybe it should be in a second country, but it is in the first. I'm going to talk for a few minutes about 2 United States statutes which govern how the courts function in this area. One is called the Alien Tort Statute, and the second one is the Foreign Sovereign Immunity Statute. These are both very current and are used, and there's a great deal of interest, and I might say disagreement, on some of the cases and how they come out. And if there's any time left, then I would like to take a few minutes talking about forum nonconvenience, the principle where you just have the case be tried in the most convenient place, and then if there's time, what we use with anti-suit injunctions. We can't keep foreign courts from doing something, but if we have jurisdiction over a party, we can enter an injunction. Those are called foreign suit, anti-suit injunctions. So let me turn first to the Alien Tort Statute. This statute's been around for hundreds of years. Literally, it was within the first few years after my country was organized, and it's very short. As we used to write statutes short in that day. That's a gift that we no longer enjoy in the United States. This statute only says the district courts, which are the trial courts, shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States. Now, the Treaty of the United States is very easy to interpret, but what is the law of nations? And typically, this statute was written so broadly that many people were coming to the United States and suing where the United States had absolutely no contact. For example, in my court, some people from Burma who were not taken care of too well by their very large corporate employers in Burma came to California and brought their suit there. Now, you can understand why. They're going to get a much better verdict, probably, in California, and the corporation has a lot of assets in California, so it wouldn't be so hard to collect. But the real question is, do we really have jurisdiction? Should our court be involved in that, even though it might be a benefit as far as the financial outcome of the person who's suing? As a matter of how courts should function internationally, should our court be involved in that? And so over a period of time, this idea of the law of nations continued to give us a difficulty in the United States. And then recently, a case called Sosa versus Alvarez Meacham came up into the United States. The case involved a very tragic involvement where an agent of the United States in the American Drug Enforcement Administration, the DEA, was kidnapped down in Mexico and held for quite a few days in which they were torturing him to secure information. The defendant was a doctor, a physician, and the government had information upon which they believed was correct, that he was keeping the person alive so he could be tortured longer so he could get more information. The government tried to get the person extradited from Mexico to the United States. It didn't work. Then they hired some people from Mexico, and the person was brought to the United States, not with his agreement. There was an indictment that took place, and the doctor was found not guilty. But that didn't end the case. He then sued Sosa, which was one of the persons who brought him across the country, claiming that this would be within the common law of the United States and a violation. Well, as time goes on, we get a series of these cases, and the Supreme Court tries to clear them up. This case went up to the Supreme Court, and the Supreme Court at that time said that what that law of nations means is what the present day law of nations could form as comparable with the 18th century form that we have recognized. A very difficult case and a very divided Supreme Court. But just last month, another case came up to the Supreme Court, which may give a little more heart to the case. This is a case of Kiobel, K-I-O-B-E-L, Kiobel. He was a worker with a group of other Nigerians out in the oil fields, and they felt that the oil companies were exploiting, and they had charges that they had been beaten and killed and raped, etc. And so they came to the United States to file their lawsuit against the oil companies. The Chief Justice of the United States, John Roberts, wrote the decision. And Chief Justice Roberts resolved the case by applying a well-established presumption in the United States that a law is not meant to have extraterritorial effect in a contrary intention, unless a contrary intention is clearly expressed. And he said, look, when the statute was written 200 years ago, they weren't worrying about other countries. They were worrying about a very short group of people, and plus they were worried about pirates. Now, this short group of people had to do with ambassadors and people that were under protection. That wasn't the issue. That's always in the United States. And pirates don't have countries. They go between countries. And he said, so this statute wasn't meant to have jurisdiction outside the United States. And so that was the ruling, even though the Nigerians had received a substantial verdict before. So Now, as it turns out, the Foreign Tort Service Act is much narrower than it was. You could sum it up by saying that under that statute, American courts have jurisdiction over violations of the law of nations involving safe conducts, ambassadorial treatment, or piracy, as well as causes of action that rest on a norm of intentional character accepted by the civilized world as defined by the forms used at that time, 200 years ago. So the case itself is not going to move a lot of cases to the United States now. The statute we're having even more difficulty with, though, and the Supreme Court has really not given us an awful lot of help, is the Foreign Sovereign Immunity Act. This particular act, the sole basis for obtaining jurisdiction over a foreign state in our country. So it's an issue that comes up, and when it comes up, it's a very difficult issue because we're talking about bringing a foreign country into our courts and litigating an issue. The statute generally operates to prevent suits from coming in against nations. That is, the groundwork for having the statute apply usually doesn't apply to nations. And so the vast majority of cases end up in we are dismissing the case and say, if you want some claim, you go to that country's courts and get them. But there are certain cases where the statute allows the country to remain in the United States for that activity. And one exception is, which is the one that's often used, is when the action is based, quote, upon an act outside the territory of the United States in connection with a commercial activity of the foreign state elsewhere, and that act causes a direct effect in the United States. So it's very narrow. It's only when the country itself is commercially involved and the particular act has a direct effect upon the United States. In my court, the Court of Appeals for the Ninth Circuit, we've interpreted this exception very narrowly. We rarely have a country in our court as a defendant because of the way that we interpret the case. One of the issues, of course, is that it has to be commercial activities. It can't be just activity. Another is that it has to have direct effect. And this also is a narrowing part of the statute, which we have treated very carefully. To have it be, have an effect, that effect must be immediate, and it must be direct, and it can't be trivial. It can't be remote or attenuated or tangential. Now, I wrote a case for our court called Berkowitz versus Islamic Republic of Iran that indicates how our court has treated this. Berkowitz was a fellow who was working over in Iran. He was a United States citizen, and he was murdered there. Now, his case was that a group of terrorists called Kavir, K-A-V-I-R, had committed the murder, and that they were actually being driven by and encouraged by the Iranian government. So the Iranian government was brought into the case. Now, the commercial activity was a little difficult to go, but the more difficult one we found in our court was whether or not there was a direct effect upon the United States. Now, the direct effect, of course, was the man was murdered. But that didn't happen in the United States. That happened in Iran. And what they were arguing was, but there was an effect in the United States, but because his wife and his children live in the United States, and they're affected by the murder. So what we held was, that's not a direct effect. That's an indirect effect. And so we dismissed the case, and if they chose to do so, they would have to go to Iran. There's another exception to a Foreign Service immunity, is when an action is based upon property taken in violation of international law. For example, a country decides they need the land to build a hospital, and so they bring a lawsuit and take the land under the statutes of the country. We will not hear that case. That's something that is traditionally done by a local case, and it doesn't fit within this particular ban. So it is a problem. When it happens, it creates a lot of difficulty. But in my circuit, we have treated it very narrow. Now, the Supreme Court has not taken up this issue yet. And some of our courts differ somewhat from the Ninth Circuit, which I think is the correct interpretation, because I wrote the case. I think the Supreme Court, following what they did with the alien case, will in all probability narrow it, but they have not been asked, to my knowledge, or at least they have not granted certiorari yet for that particular issue. Let me just take a minute of talking about forum nonconvenience. People have a tendency to go to countries where they can get more of an opportunity to win, and when they win, they get more of an opportunity of money. That's just the way the lawyers work, and we know that. But the question is, sometimes it's a wrong place. If it's terribly inconvenient for the defendant who's sued or for the court, we will enforce forum nonconvenience and dismiss the case and make them go to another jurisdiction. And there's only very few exceptions. If that country is so clearly inadequate or unsatisfactory that it's no remedy at all to go there. I haven't found one of those countries yet. And so we rarely use that. But where the plaintiff is forum and where it's unnecessarily burdensome on the defendant or on the court, then we will dismiss it. And there's a case that was a very good case called Lueck, L-U-E-C-K, versus Sunderstrand, dealing with a New Zealand issue. Once more, it's a case I wrote for the circuit. I only quote my own cases because I know they're right. And in that case, we did make them go back. As far as anti-suit injunctions are concerned, this occurs very, very rarely. But it usually occurs when it really counts. We had a case in which Gallo, who makes California wine, I know you from France don't believe it's really wine, but it's California wine, and they had an agreement with Ecuador, and the person down in Ecuador decided that they were going to file suit down in Ecuador, and they have a very strange rule in Ecuador where they can get somebody appointed in your place, and you can go ahead with the case. And this individual had only been admitted to practice for 5 months, and it was pretty bad. We had a district court, trial court judge who thought that it was okay. It came to our court, and we found it was not. And in that case, we entered an injunction that the plaintiff themselves had to come to California to make that suit. Now, was that a bad deal? No, not at all. In the contract between the two people, they had agreed all lawsuits would be brought in California, and California law would apply. He attempted to make an end run around that agreement, but we enforced that agreement by entering an anti-suit injunction that he could only try it in California, and finally the law was filled in. I know I've taken a little bit of time, but this is a very complicated area, and this gives you some view of how we're handling or attempting to handle some of these very complicated cases. And I thank all my colleagues that I've heard from so far. I really enjoy these international areas because I learn so much from other people, and I have already today, and I want to thank in advance my colleagues.
Thank you. Of course, I would like to ask a question, as my tradition is, but I believe it's a rhetoric question because I can't see a solution to this problem. I wanted to attract your attention to the case of Schneerson's library. When one judge of an appeal court decided that the library must be returned, or rather extradited from Russia to the Hasid community, despite the application for, despite the foreign immunity, and the other judge appointed a fine for non-enforcement of non-compliance with this up to the amount of $50,000 a day. Several $1 million have been accumulated. The Russian Federation objects to the American jurisdiction of this case. Of course, it's an old case, but quite recently, the President of Russia declared that the library will never leave the boundaries of the Russian Federation. So what do we do?
Well, perhaps you and I could sit together for an hour or so and decide through arbitration and mediation what happens not infrequently is that judges make decisions other judges disagree with. I have read the case. It involved some very ancient Jewish writings that were here in Moscow, here in Russia. And part of them were taken by the Germans when they invaded, but they were brought back. And so there were some complications between one group, which was called the library, and the other group, the name of which I've forgotten. This particular case, if you read it and you compare it with the case that I cited, you'll see a different approach. What the Court of Appeals, there are 3 judges in the panel of the District of Columbia Circuit, and the decision came from there. The district judge enforcing what came back down was the one that entered a fine of $50,000 a day. Now, I don't want to be critical with judges in the United States, but when I was a district judge, I would never have done anything like that, no matter who it is. I mean, there's a very valid legal question that's involved here in an area where we've been restricting our jurisdiction. Now, why would you punish the person with that type when they still have another area to go to the Supreme Court, which just last week restricted the jurisdiction of the Alien Tort Claims Act? It shows that in the Supreme Court of the United States, they're trying to decrease this. So I can't very well speak for the D.C. Circuit or the district judge that did it, let alone the Supreme Court. But it's an area that cries out for certiorari being granted, and I hope the Supreme Court, I hope the Russian Federation will ask for certiorari and that it'll go up. Now, very often, these issues become very political. And the president of the Federation, Russian Federation, is not known. He doesn't have a reputation for backing down. And I suspect we have a president over there who may listen. I know his predecessor liked Mr. Putin very much. But this is an issue, the type of issue that very often is solved in a different way. But if the courts can solve it, I think they should. Now, will that happen? I can't tell you, but I think, Mr. Chief Justice, you and I can sit down and solve it.
Thanks a lot. I would like to pass the floor to Daniel Tardif, the head of the Constitutional Court of France. Yes.
Attendez. Là, ça fonctionne. Ça y est, c'est bon. Curieusement, ça fonctionne. It's good when it's red, in France when it's green. Mr. President, ladies and gentlemen, it's a great honor and a real pleasure for me to speak to you in St. Petersburg, and I want to send to you the best feelings from Mr. Vincent Lamanda, President of the French Cour de Cassation, and a great friend of Flusha, as you know, Mr. President. As I explained to Mr. President Ivanov, I have a little problem, because I thought to be able to speak in French, but it's impossible because there's no translation in my native language. So I will try to speak in English, and I apologize by advance. So it's the reason my speech will be very short, but it's late now. I want to speak to you about foreign inconvenience, and it's very easy for a French to speak about foreign inconvenience because it doesn't exist in our legal system. But it's not all, of course. In our system, the law, and only the law, decide if the judge is competent or not. It's impossible for a French judge to have the liberty to refuse to know a case because it's not convenient. In France, we know we have only the possibility of litispendence. I don't know the English term for litispendence, I think it's in Latin, and connexity of case. But it's very different of a foreign inconvenience. However, sometimes we know this particular procedure. In this way, the French Cour de Cassation gives a very important decision, December the 7th in 2011. It was about an aircraft crash of West Caribbean Airways in 2025. In this case, the French Cour de Cassation gives a full effect to the Articles 33 and 46 of the Convention, which provide the choice to the best forum for the plaintiff. This decision was on the basis of Article 33 and 46 of the Montreal decision. In accordance with the text mentioned, where is the choice of jurisdiction which is provided by them, object that the dispute will be settled by a different court, that it was chosen. Indeed, this option, which was accompanied by an exhaustive list of relevant fora to consider the various interests involved, implies to achieve the objectives of particularly security and standardization pursued by the Montreal Convention, that the applicant has, on himself alone, the choice to decide into which court the case will be effectively resolved, without to be opposed an internal procedure rule leading an antagonized and imperative choice. his imperative choice. Whereas to refuse to relinquish the dispute, the judgment held for this reason that the Court of Fort-de-France in Martinique derived its power to judge from a rigorous application of the rules of jurisdiction of the Montreal Convention, and that, because of this intrinsic reason, among the different jurisdictions resulting from this convention, there is the court of the place of destination of the flight. That is to say, this one from Fort-de-France, and the jurisdiction should be questioned under the pretext of a lack of judicial power. While the plaintiffs have chosen another competent court to resolve the dispute, the Court of Appeal violated the text when they are ruled in this way. In other words, the Cour de Cassation considered that the option of the competence belongs to the claimants and only the claimants, though there is no reason why the convention option is reduced by a state. Thus, the principle of the foreign non-convenience argued by American judges cannot prevail on a treaty which provides the possibility for an applicant to choose a jurisdiction. The judgment deals with another important issue in procedural terms because the court considers, regarding the international area, the receivability of some declaratory action. Consequently, the court returns the case before the American jurisdiction which were recognized incompetent. Eventually, the Court of Cassation considered the French forum is not available. This position, of course, could be dangerous for the claimants because they don't know if their case will be judged by courts. In French, we call this situation a déni de justice. I don't know the English terms. The claimants have no judge now. But it's really a great problem for the future for the claimants. That's all.
Спасибо.
Thank you. We only have a tiny bit of time left. I won't ask my traditional question, but give the floor immediately to Mr. Quentin Law, Judge of the Supreme Court of Singapore.
Thank you, Chief Justice. And thank you for this invitation to speak here. One of the good things of being last is everyone has said everything that needs to be said. So I'll be quick. Singapore has always depended on trade. We're a very small nation, and we've therefore always had an international outlook. So the first thing we have developed within our jurisprudence is to respect the International Committee of Other Courts. We do not second-guess other courts, and we are quite careful about our jurisdiction. We enforce forum non-convenience if somebody comes forum shopping. We also have the concept that was mentioned by my French colleague, lis alibi pendens. If somebody has started an action elsewhere, we'd be very careful if they start another action in Singapore, because that smacks of forum shopping. But you see, there are some things that we can't help. With modern communications and globalization, people are doing trade across borders more widely, more quickly, in more diversified ways than ever. People get married between Americans and Singaporeans, and they have problems with custody of children when it breaks down. So national courts cannot avoid these international issues. 3 weeks ago, somebody came before me, and he was the leader of one of the two national parties of a big nation suing one of the other leaders of the other national party who was in power. And he came on the basis of defamation. How do you find jurisdiction? On the internet, the reason is they say the publication of the defamation was in Singapore. Why? Because some of his supporters went on the internet and heard the defamatory remarks. So he said that was Singapore. Well, it's an ongoing case, so you can see the problems we face when we deal with these issues. I think, too, there is a very urgent need because of this internationalization for cooperation amongst courts. We are going to face these problems more and more. Singapore has done two things. When we had a question of English law, which had to be applied in a Singapore court, instead of listening to two experts, one who will sure to say the answer in favor of party A, and the other expert saying it's in favor of party B, what does the Singapore court do? We've got to make a choice. So now what we did was a year and a half ago, we referred the question to the English court. And we told the English court, by consent of the parties, this is a question of English law. It needs an answer according to English law. You tell us the answer. And the parties agreed they will abide by the English judge's decision. And I think that saves parties a lot of money. We've also signed a formal memorandum of understanding with the New South Wales court that if a question of New South Wales law arises in Singapore, if the parties consent, we'll refer it to the New South Wales court. The understanding is if such a question comes before you, you deal with it as quickly as possible and send it back. So we, in Singapore, if you have such a question for us, we'll deal with it within a month or 6 weeks. As fast as the parties can do it, we'll give you the decision. We also respect party autonomy, so we do issue anti-suit injunctions, but very limited. We also respect the choice of arbitration as a dispute resolution mechanism. If the parties have chosen that, we will not interfere. We will respect that. And as far as enforcement is concerned, and coming up to removal of arbitrators or such matters in international arbitration, Singapore courts adopt minimal curial intervention. Unless ancestral or model law allows us to intervene, we will not intervene. Unless the New York Convention allows us to intervene, we will not intervene. So that's how we keep things going. And as many of you know, Singapore has grown very fast as an international arbitration center. But international arbitration itself has its problems. They're no longer as cheap, as fast, or as efficient as they used to be. And there are a lot of complaints about that. So in Singapore, we are very fortunate in being placed between three big economies, China, India, Indonesia. And on top of that, we've got the Indo-Chinese countries whose systems of law are not very well developed. So we intend to set up an international commercial court where jurisdiction will be consensual. The parties will agree to come before the court. We will do away with party-appointed arbitrators, because there's an amazing statistic that you will find. Two different authors have come to this conclusion. 95% of dissenting awards in international arbitrations are from the party-appointed arbitrator whose appointor lost the case. What does that tell you? 95%. So in this new commercial court, we will have associate justices. They will come from other jurisdictions, well-known judges, well-known arbitrators, well-known jurists. Allocation will be by the Singapore Chief Justice, so you don't have to worry about party-appointed arbitrators. We will also have consensual arrangements and reciprocal enforcement arrangements. For example, the same reciprocal enforcement that exists between the Dubai Financial Court and the English commercial courts, which means that if you start a case in Dubai and the Dubai court says it should be dealt with by the English court, they will refuse jurisdiction and send it to the English court. And then it will be binding if you if you litigate it there. And after the English court has given its judgment, it will be enforceable in Dubai as a recognition of a foreign judgment. So that's the basis on which we will go. And given that the time is short, Chief Justice, would it be good to stop there? Yes? Thank you.
Я тоже ввиду
Yes, since we have run out of time, I won't ask any questions, but let me give a brief comment recalling a well-known case between Berezovsky and Abramovich. If the English court, the case that should have been considered according to the Russian law, if the English court had been transferred it to a Russian court, it would have been done simply and easily, because you can't refer to witnesses unless you have a written contract in place. This is according to Russian law. So whoever tried to prove anything according to Russian law, the plaintiff would have lost unavoidably for want of a written contract, but instead the parties could have saved huge costs. I think it was approximately 300 million pounds. Maybe some sad events would not have followed suit. Who knows? Well, in concluding this discussion, I'd like first of all to say thank you to all the participants for their contributions, creative contributions that they have made to this discussion. And let me emphasize that this has been an important discussion for all countries, all nations, including the Russian Federation. I only have to note two things here that have happened over the last year in the Russian Federation. What I mean is a well-known case of where the English court decision was recognized in the absence of a written contract in place between the Russian Federation and the United Kingdom. And the second story was the draft law submitted to the State Duma. That bill relates to the consequences of the award made by foreign courts while violating the rules of jurisdiction. The bill goes to provide the guarantee to Russian citizens or Russian legal entities against unjust consideration, undertaking the commitment to handle the matters with foreign jurisdictions. I don't know the destiny of that bill. It is still under consideration. We don't know the outcome, but these are two important events that are worth mentioning, and they could have some influence on the overall situation. As for the issues here overall, I think everybody agree that this problem is really there. I wouldn't say there is no conflict of jurisdiction. It exists. There is competition of legal systems. And if we want to develop well, we need to play this game of competition and try to win. Provided there is a chance for us to do so. Thank you for your time.